from the Quebec Intellectual Disability Society, Ms. Amélie Durand-Lot. Ms. Durand-Lot, you have 5 minutes.
Merci beaucoup.
Thank you very much, ladies and gentlemen, members of the Special Joint Committee on Medical Assistance in Dying, MAID. We would first like to thank you for the opportunity you have given the Quebec Intellectual Disability Society today. We wish to make it clear that our organization is not opposed to medical assistance in dying for people nearing the end of their lives. Rather, we ask that adequate safeguards be put in place to ensure that no abuses occur. We believe that legislators must be cautious and consider the systemic forces that could threaten people with disabilities and specifically people with intellectual disabilities. It should be noted here that intellectual disability, or disability in general, should never be a criterion for access to MAID. With the necessary support and appropriate accommodations, people with intellectual disabilities can live fulfilling and rich lives. If people find themselves living with intolerable suffering related to their intellectual disability, it is because society does not include them and they lack services. The Society is also very concerned about the possibility of authorizing substituted consent for incapacitated persons at all stages of MAID applications. This possibility had been raised by the Quebec National Assembly, and even such a question is not under consideration today. It is important to discuss it. On the one hand, the use of MAID should always be tied to the validation of a free and informed consent from the person who will receive it. On the other hand, it may be difficult to assess this consent for incapacitated persons, especially those with a more severe intellectual disability. These persons may experience distress in relation to the death of someone close to them, but it is generally more difficult for them to understand the permanent and irreversible nature of their own death. We therefore call on the legislator not to allow substituted consent for those who lack capacity to consent. Regarding the legislator's desire to potentially allow the use of advance directives for access to MAID, we would like to refocus the debate on the issue of the validity of consent in these situations. Asking a third party to consent to a procedure that leads to death through a substituted decision-making process is different from making advance requests to refuse certain procedures that may lead to natural death. In this light, opening the door to substituted consent, even for people who had previously consented, seems to us to be potentially dangerous and to fail to respect the spirit of the Carter decision, which put the issue of consent at the heart of access to MAID. In our view, it is important to provide satisfactory alternatives for people with disabilities. This position has been advanced by the Canadian Human Rights Commission. Universal and high-quality public services in sufficient quantity must be provided to people who need them. Indeed, this is an obligation that Canada has towards people with disabilities under the Convention on the Rights of Persons with Disabilities. Thus, satisfactory alternatives are needed to provide a dignity of life for people with disabilities and for the Canadian population in general. As mentioned previously, we believe that MAID should be a measure of last resort for people who are capable of giving free and informed consent and who, at the end of life, are living in unbearable suffering. We also distinguish between the issues of advanced care directives and advanced directives in relation to MAID. The former allows for natural death, while the latter entails the use of an active procedure that ends life without clear and validated consent. Furthermore, we believe that substituted consent should never be allowed for incapacitated persons, as they cannot provide free and informed consent. The Carter decision put the issue of consent at the heart of access to MAID. It is important to respect this fundamental principle of health, justice, and ethics. Finally, in the event that people with intellectual disabilities at the end of their lives make an application on their own without any undue pressure, then we believe that they should be assessed like all other people, as long as their access to MAID is not granted on the basis of disability. However, it is important to have stronger safeguards in place to prevent ableism and the devaluation of the lives of people with disabilities. Thank you.
Merci beaucoup, Madame.
Thank you very much, Ms. Durand-Leau.
And
To
the
Mr.
first questioner will be MP Dominique Vien.
Merci beaucoup, Madame.
Thank you very much, Madam Chair. Thank you to our witnesses for meeting with us tonight, despite the late hour. Ms. Durand-Leau, good evening. Thank you for being here. Everyone who has an intellectual disability, well, it's concerning when we talk about medical assistance in dying. I'm not super knowledgeable, but there are degrees of intellectual disability. And I understand that you're against, and if I've misunderstood, you can let me know, but I've understood that you're against medical assistance in dying administered to those with an intellectual disability. So would there be a spectrum of intellectual disability? Yes, there's a spectrum. And when we talk about medical assistance in dying, those who are incapacitated, that would only be one portion of people with an intellectual disability. We'd specify that those who have an intellectual disability, many of them could request it themselves because they are able to make decisions about their own lives. I'll let my colleague Samuel Rago complete my answer. Thank you. Certain people who have a lighter intellectual disability are quite capable of requesting the procedure for themselves, by themselves. What's important is that it be done without undue pressure, that there's truly free and informed consent, and that the made request not be done for economic or social reasons, that it really be at the end of life due to intolerable suffering. So track 1. So you would really set a condition. That's what I'm understanding tonight. Yes. What type of abuse do you fear? What worries you? That's an excellent question, Madam Co-Chair. What we hear, and it's tragic, what we sometimes hear, it's parents who are aging, who have children, who may be in their 50s, who have an intellectual disability, who have few to no services, and they wonder what will happen to their children when they themselves die. And sometimes we hear parents who tell us, look, if I could request MAID for my children, I would. That raises significant questions. These are tragic situations. And the answer probably isn't MAID. The answer would be a social answer to provide services, to provide housing, financial security to people. That was discussed earlier. So these are things we hear. And we hear it more and more often, unfortunately. Would you say that people who have an intellectual disability are aware themselves of medical assistance in dying, or it's brought up with them? That's a question that's difficult to answer without generalizing, but certainly we've heard in the newspaper people who had MAID proposed to them because there weren't services. So would there be medical pressure that the lives of people with disabilities aren't valued as much? Certainly. Would some people present legitimate, valid requests with free and informed consent? Certainly as well. But what's more concerning, of course, would be undue pressure, MAID being proposed by default because there isn't anything better. You were talking about substituted consent that would be when someone can make the decision for a sick child, or rather, who has an intellectual disability. Is that correct? Absolutely. You talk about it because you hear from parents, well, who say, like, look, if it existed, that's what I would choose. Absolutely. It's also something we've heard in Parliament in Quebec, something that was refused in Quebec. It's not in the new law that was tabled. But yes, substituted consent is something that has always been, well, rather than giving real legal capacity to people, rather than giving them tools for them to exercise their own rights, often it's been substituted consent given to parents and families. And that's something we hear in relation to MAID.
Next, we will have Dr. Fry. You have 5 minutes.
Thank you very much, Chair. Today, I guess I heard a lot of compelling evidence of both people who were disabled and for people with intellectual disabilities. And I think all of it makes a lot of sense. Obviously, if we had a system in which we could give everybody the support that they need, both economically, psychologically, and socially, with support systems in place for them, then if people, having lived with that, still believes that they would like to, with informed consent, access MAID, I can see that happening. But I think you're absolutely right. I was appalled to hear some stories today about people who chose MAID purely because they were living in poverty and couldn't even afford treatments. So I think what are the kind, I mean, I could ask you what should all three levels of government do to give that kind of access, to create a system in which, when you look at all of the psychosocial supports that are needed, that they are there, that they're done. What would you suggest we do, all three levels of government, to create a seamless system? Because the provinces are responsible for thing A, federal government is not responsible for it, and of course we have a patchwork across the country. So what would you suggest?
Any witness?
I'll ask Monsieur Olago.
Merci pour votre question.
Thank you for your question. It's a very difficult question to answer, but of course, as our colleagues from Canada, Disability Without Poverty, have said, it takes money, decent income, quality, accessible public services, housing, safe housing that's accessible, of high quality, that's adapted to the needs of people with disabilities, transportation that allow people to get to work, to get people to their services. There need to be psychosocial services, psychotherapy, a whole range of services for people with disabilities, a patchwork of services.
Next, we'll go to Mr. McGregor, followed by Mr. Thériault. Go ahead, Mr. Thériault.
Mr. Thériault. Thank you, Madam Co-Chair. My questions will be for the Quebec Intellectual Disability Society. First, the Quebec Association for Dying with Dignity said in a recommendation that there should be a ban for eligibility for MAID for people who have intellectual disabilities that are serious unless there is absolute certainty about the decision-making capacity of the person. So I was reading your brief for the Quebec Commission in July 2021. So that reflects your second recommendation, which would be banning substituted decision-making for people who have an intellectual disability who are deemed unable to consent. So I would imagine that could reassure you if I look at the other recommendations you've made, which seem good and would be good medical practice, and I think would reflect what's happening in current medical practice, requiring people who have an intellectual disability to only request MAID if they're at the end of their life. So here, I think we've gotten into the gray area between incapacitated and able to request it. And in such a case, I'd like to know how that would work. How do you determine capacity? Do you have an example of that gray zone to provide to us? Either Ms. Durand-Leau or Mr. Dago, if you've understood the question. Mr. Dago, yes. Thank you. It's a question that's really not easy to answer. What research seems to indicate is that people who have an intellectual disability understand the death of people around them. That's pretty clear. They understand it. They have a capacity to really experience those situations. What's less clear is, are they able to understand the irreversible aspect for themselves? And so here's a gray area that's very difficult to determine. Well, specifically in Quebec, the difference between medical consent and legal consent for signing a contract is really based on tests of understanding of the medical acts being discussed. I don't think we have perfect tools at this time. To my knowledge, there's no perfect tool to determine whether a person really understands if they were to request MAID or not. And it depends on the severity of the intellectual disability. You would say that a doctor who has a background in intellectual disability should participate in the request. I imagine that's a corollary of what you've explained, and to me it's totally natural. You've raised questions about social and economic inequalities, and I think that assessors need to take that into account, of course. That was raised in the expert panel report on mental health. You've said that any request for MAID should have a mandatory declaration by the health professional. What are you thinking of? Because there are already reports. There's a commission in Quebec that looks into each medical act that is done. So do you think there needs to be something more, or are you just saying well, what form would that take? So there was this standard for protecting vulnerable people that was proposed in the first bill on medical assistance in dying. And that standard proposed measures to look at the social determinants of health and other determinants of people's vulnerability, and said that there should be more comprehensive documentation to look at the real reasons that may be less clear when it comes to medical assistance in dying. So that's what we're also calling for, because we know that many determinants of health and vulnerability motivate some people who request MAID. Your 7th and 8th recommendations requiring discussions on MAID to be only brought up by patients, and the 9th, talking with the immediate family when assessing a request for MAID in the case of intellectual disabilities. I think these are measures that should be part of medical practice. Do you have the impression that assessors or providers wouldn't be open to that? It seems that the medical world would be open to that, and it's totally natural to talk to the family. Absolutely. I think it's about avoiding requests done under pressure by medical staff or other. That would be ableism. So protecting people from a devaluation of their life and undue pressure. Senators, beginning with Senator Mégie. Senator Mégie, you have 4 minutes. Thank you, Mr. Chair. Thank you to the witnesses. My question, I think, would be for all of our panelists. Perhaps one or two could answer. What I wanted to say is that normally a doctor or any healthcare professional must explain to a patient all of the treatment options, whether it's palliative care, intensive care even, all of the options. However, from the anecdotes that I've heard in the media and from witnesses, I have the impression that these people either requested MAID or were forced to ask for MAID. What do you think, as people with a disability, do you have the impression that wherever you go, you will be forced to ask for MAID, even though you should be the ones requesting it? Is that something you fear?
Alors, on pourrait peut-être commencer avec...
We could perhaps begin with the Quebec Intellectual Disability Society.
C'est une question.
That's a question that's very difficult to answer, but we can start by saying that ableism is something that's very insidious. It's not open, it's not obvious, it's not explicit often. It's in attitudes and social judgments and obstacles that people encounter in society. And sometimes it can also be at the medical level, of course. I think an answer would also be that there's a lack of services. We've seen there are staff shortages in hospitals. Our healthcare services are in a poor state, especially after the pandemic. And indirectly, that can lead people to head towards MAID rather than receiving services. That's often what we hear on the ground. But you could refuse if it's offered as an option. If another option is available, certainly, but that's often not the case. If, for example, the government did everything it could with proactive measures to address all of the obstacles to systemic inequalities, I don't want you to tell me I'm dreaming in color, but let's suppose, do you think that everyone who had encountered inequalities in access to health care, would they not have the same inequalities in access to MAID? So who are you asking the question to, Ms. Thériault or Mr. Thériault? Could you repeat the question? I'm not sure I really understood it correctly, honestly. Because of all of the systemic inequalities that certain groups experience, I'll shorten this, in the same way that you have difficulty in accessing care and services, why would it be easier to access MAID? Because it's a measure that's not expensive and that's very easy to organize and administer to people. And that's just simpler. It requires less work, less systemic work, less work on biases, less money from government. It's just simpler. Certain people, I'm not saying it's our position, but certain people have talked about eugenics. It's a term we have to be careful with, but it could be raised potentially. Thank you very much. Thank you very much. This brings us to the end of our panel. I'd like to thank our witnesses tonight. Ms. Jocelyn Landry, thank you for your very personal testimony about your father. Thank you to the Quebec Intellectual Disability Society. Ms. Thériault and Mr. Thériault, thank you for your testimony and for having answered our questions.
Mr. Conrad Solis, thank you very much for coming this evening and providing us with the perspective, the Indigenous perspective on this very, very important subject. We very much appreciate it. With that, this brings us to the end of this evening's committee meeting. So with that, we are adjourned.